Good evening, everyone, and welcome back to the Brian Crombie Radio Hour on Saga 960. So there's an issue in condominium development that's been going on of late, and it's cancellations that have really, created quite a buzz and a couple of articles in the newspapers about it. And so I wanted to reach out to two lawyers. Well, a lawyer and an articling student lawyer who I've interviewed before and are quite impressive. I want to introduce you again to Lior Margulies, who is the head of real estate legal work at Robbins Appleby, and articling student Erin Lee, who is one of the most impressive young ladies I've had the privilege of meeting. And if Lior's smart, he's going to offer her a great job, and she's going to do incredibly well at Robbins Appleby. So Lior and Erin, welcome to the show. How are you?
I'm good. I'm great. Yeah, no, it's a great day. I'm a new grandfather of 3 weeks. I sold my condo. I had a investment condo. I sold that. So I've had a great few weeks here. No complaints.
Awesome. And Erin, you're doing well?
Yes, I'm well. Thank you, Brian. And thank you for having us back on. It's great seeing you again.
Yes. My pleasure. So let's talk about this. So there's been a bunch of pre-construction contract cancellations that have become big news over the last couple of months. The CBC and the Toronto Star have been full of stories of these cancellations, delays in government approvals, further compounded by COVID-19, together with delays and lack of availability of supply and labor due to COVID-19, have created sort of these unavoidable delays, forcing developers to extend their closing dates. As a result, many projects have become unfinanceable and uneconomic for those developers who sold early and whose revenues are fixed with costs escalating well beyond budget and eating to or eliminating profit. Lior, what's happening here?
Well, you sort of summarized, what's going on here. I mean, this has been going on. It was going on even before COVID started, the issue of escalating costs. But, COVID certainly exacerbated the situation because it increased delays in government approvals. They were already exceptionally slow, and that's a whole other story. And then it affected the supply chain, labor, materials. And so what's happened is a lot of projects, and now you're starting to see them on the low-rise side. This story is not really new. There was a whole spate of condo cancellations, I'd say, about three years ago that were in the news, and that had the government coming down Ontario to tighten up the review of projects and builders on canceling, and they had come up with some new disclosure and requirements. But that was usually the high-rise side. Now, because of the supply chain and the delays, low-rise builders are facing the same issue of these escalating costs. And the problem is particularly, and if you examine most of the canceled projects, both high-rise and low-rise, it's those developers who've gone to market, unfortunately, early, and then got stuck because of either the supply chain or because of the delays in government approvals to get them to market. So by the time they go to start the construction process, and because of that, they are now facing costs that they didn't budget for because costs have gone up dramatically, but they pre-sold 1, 2, 3, 4 years ago, and they're stuck with fixed revenues. And it's those projects that are becoming, as you said, somewhat unfinanceable because they're uneconomic. And it's those projects that you're seeing builders where they have the right to do so. And that's an interesting point. You can't just cancel your project because it's uneconomic. Tarion has very strict rules as to what rights a builder has to terminate, and there are only generally 2 or 3 bases for terminating a contract. If you put it in your contract, if you go firm, then of course you can't contract. You can't terminate. And it's in this case, in most of these cases, it's the financing condition that's been used to terminate purchase agreements, both low-rise and high-rise. And you're seeing a lot more of these because they can't finance them. It is true. Because of the gap, your revenues are too low, and your costs have gone up too high.
Are these like questionable deals that shouldn't have gone ahead, or are these just what were good deals, but escalating costs made them questionable?
Well, they're not questionable, for the builder. That's why, there's an advantage to purchasers on low-rise and high-rise side to get into the market, get into the pre-construction early. The earlier you buy, the better price you're going to get. if it hasn't gone in the ground, if it started in the ground, if it's finished, prices are going to continue to go up because, what did I do here? You put something up here. Prices are going to continue to go up as the risk reduces. So purchasers take a higher risk when they buy earlier, and vendors take a risk when they sell too early. So both of them are taking a risk, and these termination clauses are there really to protect the vendor in the event that he sells and then can't get financing. And so is this questionable? No, I think what you're seeing now, the more prudent builders are realizing that you can't separate the time frame between setting your revenues when you sell and setting your construction costs when you're going to build. And you can't build until you have your permits. And that's the whole other issue.
So are developers selling their condos too early? Is that the problem?
Condos or even low rise, they were. That's true. Because you wanted to get into the market early, nail down your purchasers, get before the market changed. But of course, because it's taken that much longer with government approvals, and then even that much longer because of COVID, you're getting such a gap of time. You can't fix your prices 3 or 4 years before you go into the ground, or 2 years. Nobody's going to do it. So it's those projects. If you examine most of the cancellations, it's those projects that sold too early. Nobody did it to hurt anybody, but that's the risk that a purchaser takes on buying pre-construction. The earlier they buy, the higher risk they take, but they also get the benefit of the lower price.
But the risk is that they may have priced it too high, or that the developer might cancel. Anyway, it's fascinating conversation. We're going to take a break for some messages and come back more with Lior Margulies and Aaron Lee of Robbins Appleby Law Firm, talking about condo cancellations and the implications in just a minute. Stay with us, everybody. Welcome back to the Brian Crombie Radio Hour on Saga 960. So this is interesting issue that Lior Margulies of Robbins Appleby has been telling us about, which is cancellations by condo developers and even some low-rise developers when I guess their construction costs have gone up. Their revenues were already set because they sold their units previously, and what's the right that the purchasers have if the contracts are canceled. And I understand there's a case that had become quite noteworthy called the Green Urban case that, Aaron, you're very familiar with. Tell us a little bit about the case, if you could, and what the implications are.
Yes, thank you, Brian. So Green Urban was a November 2021 Ontario Superior Court case, which stemmed from a condo development in Tillsonburg. So Green Urban had sold 26 municipal freehold common element condominiums pursuant to agreements which contained early termination conditions. Then the builder, citing non-fulfillment of these conditions, terminated for development approvals, or they did not receive these approvals, canceling the sales, but offered the purchasers to sign new agreements whereby the buyers would pay an additional 25%. And the condition that the builder was citing ended in October 2020. And unfortunately, the builder did not provide notice that they were using these termination conditions until June 2021. After the builder had realized that the costs had increased, as Lior was discussing, and realized that since they had not received the necessary approvals, that the deal had technically been terminated the previous October. So 18 of the 26 purchasers decided to pay the increased cost and sign new agreements. However, 11 purchasers decided not to. And these purchasers brought the builders to court to seek certificates of pending litigation, which is basically a notice registered on title that says that the plaintiffs have an interest in land pursuant to a certain claim and notifies potential purchasers going forward. And so there was provisions in the addendum which said that they would have to go to arbitration. So for the ultimate decision of whether the early termination clauses were valid in light of a number of technical objections, they will have to go to arbitration. However, the court held that it still had jurisdiction to issue a certificate of pending litigation. And in cases like this, the court basically looks at the facts and decides what the result should be, and then finds the law to support it. So here, the court felt that the builders were the least innocent of the parties and decided to grant a certificate of pending litigation for the purchasers.
Which means what? That the purchasers don't have to pay the increased price, or what?
No, the certificate of pending litigation is basically a notice registered on title, which informs people, for example, potential purchasers in the future, that these people who would be the plaintiffs might have an interest in the land.
It basically stops the builder from reselling the property or remortgaging it. It freezes it, because if ultimately our original purchasers are successful, and they'd have to be successful not only in confirming in getting the arbitrator to say that the builder didn't have a right to terminate, but also ordering specific performance. It's really two things that these purchasers have to succeed on: the technical objections, which we won't go into, and that will be dealt with at arbitration, but more importantly, the ability of a purchaser to say, to get an order that says, you builder, you terminated wrongfully, I can get the court or the arbitrator to force you to close the deal with me. And that's a very unique result for real estate. That you could get damages, that's the norm, you know. And it would normally be the norm here. They were townhouses that they sold for maybe 500, they went up to, say, you know, 700 or 800, and the difference in price would be your damages, and then you'd be whole. But the court said no. The unique part about this case, very unique, that the court felt that they could order specific performance if the purchasers were ultimately successful, because these properties were unique. That's sort of the real test for specific performance. You don't get that automatically. If you have a contract that says, you know, you have to do something, or you have to sell me this house, you don't necessarily get an order that says you have to fulfill the contract. Generally, the court will say, you know, we'll pay you, you know, we'll award you damages to put you in the same spot. But this court said these properties were unique, and that's okay. If they were normally unique, would be you can't replace the property. It's a very unique location or build or something. They said no, they're unique because to replace them will cost you more money. It's honestly, I think that's wrong from a legal perspective. But he tried to do something for these purchasers, because this way they've got their property sitting there waiting for them to at least have a chance to get it if they're successful. Because if not, the builder could have sold the properties and then he would only be liable for damages. So it's a very quite something in that for the court to have done that. But they just felt that the purchasers had been hard done by. That's my. But
the stories, and you know, maybe, you know, like lots of stories can be one-sided. But the stories that I've read about these are heart-wrenching. That you know, different families, newlyweds, etc., have invested a substantial amount of money in the deposits that they put in place to secure the townhomes or the condos or whatever it was, and effectively, as you know, the articles are saying, the developers just came along and said, you know, so what? I don't care that we've got a contract. Pay more or forget it.
Well, okay. I mean, I think you're being just a little cavalier in describing the results. It's a pre-construction contract. The vendors are allowed to protect themselves in case they can't get financing. Essentially, that's the condition. In the Green Urban case, it was a different condition. It was a condition that said we have to get necessary government approvals, severances, and so on. And if we don't get those, which if you don't get them, you can't build, we can walk away. So those are basically the only two conditions that Tarion allows builders to use to walk away. And purchasers know that. It's right there in the agreement. There's no secret. And that's why I go back to my whole point. It's a risk analysis. If you don't want to take the risk, you, the purchaser, don't want to take the risk that there could be a cancellation because of the gap in time. It might be 2 years that this condition is out there. Then don't buy pre-construction with a condition. Wait till the guy's got the shovel in the ground. You may pay more, but then you know it's going to go forward. Same with a condo. Don't buy pre-construction, you know.
So, Aaron, do you think that the court made a mistake there?
I think, as Lior was saying, on a legal basis, there was a mistake because, as he was saying, uniqueness is not usually measured by an increase in cost, because that can be quantified by damages, and specific performance is supposed to be meant for situations which cannot be covered by damages. So I think that there was a legal error there, yes.
But, it's interesting because, they could have just seen, the developer could just seen that prices have gone up and I don't like the deal that I negotiated previously, and effectively renege on the deal. And, financing condition, Lior, the developer can always engineer the lack of financing, right? Like to get the financing is completely within that control, because they're the banker is going to be asking for a certain percentage of the condos to be sold. They just don't sell this certain percentage, or they're going to be wanting certain recourse or guarantees, and they don't provide that certain recourse or guarantees, or they don't provide the information for the due diligence. So when you've got a financing condition, the problem with the financing condition is it's not really truly an external issue that is beyond the control of the developer. The developer can have a significant influence on whether or not that financing condition is met.
Well, that presupposes that the developers are looking to get out of their deals, and 99.9% of developers don't want to do that. It doesn't help your reputation, and it doesn't help you with HCRA, the regulatory authority to license you, and it doesn't help you with Tarion. So let's put that in perspective. But more importantly, the agreements require you to do everything you can to fulfill those conditions. You can't just like sit on your hands and not apply for your approvals, or sit on your hands and not get your financing. And now Tarion, and since, when I said there was a change a few years ago with the condos, because I was on that committee, the government said, you got to do something. So now there's two things. Number one, we warn purchasers very clearly. There's for condos, there's a form that you have to be, deaf, dumb, and blind not to understand that you're taking a big risk buying pre-construction with these conditions, number one. But number two, Tarion now is taking a very close look when they're registering projects, and they're looking at the economics. They're looking for your ability to finance. They say, okay, you're putting up a 30-story condo. Do you have where's your financing? Do you have lenders in place? Let's see the project economics. So they're taking a much closer look up front. And when there is a cancellation, and I was involved in a cancellation for a client, it was appropriate, but Tarion reviews things exceptionally carefully. And if you're offside, if they feel that you've not been acting fairly, two things can happen. Number one, HCRA, the licensing tribunal, it'll come down on you. They can fine you. They can take away your license if you've not been treating consumers properly, and they're looking at those. Number one. Number two, the next time you come to Tarion and you want to register a project, they're going to come down on you in terms of the security you post and the release. So there's a lot of practical factors that militate against developers who want to stay in business from doing the type of things that you said, not really
reneging on a deal.
Finance. Yeah. So yes, it could happen, but I would say it would be a very small majority, and those would be the bad eggs. And you'll get bad eggs.
So you don't think it's just because condo prices have gone up that these developers are wanting to cancel? It's because truly their costs are gone up, and they can't make an economic construction project anymore.
Yeah, where they're doing it. Yes, in 99% of the cases, that's correct. Because they won't get financing, or even if they could on reasonable terms, they would do it, and they wouldn't get it because no bank is going to lend where there's no profit. The project that we had to cancel, unfortunately, we took it over when we looked at the numbers. The client was going to make a 1% return. No businessman will do that, let alone no bank. But the case that the urban green case is sort of unique because it was a development approval clause that they used, and there it's actually automatic. If you don't have with a financing condition, it's up to really the vendor to decide if he wants to rely on that condition or waive it. But for development approvals, if you say I have to get certain approval by a certain date, if you don't get it, the way that it's worded, the contract is essentially dead. You don't have to you don't do anything, and you can't waive it.
Okay, so what's the position? And maybe Aaron, this. What's the position for the the potential buyer? Do they get their deposit back? Do they get it with interest? Do they get it promptly, or do they lose the deposit?
Here, I believe that they would have received the deposit back. Lior can correct me if I'm incorrect. But just in the Green Urban case specifically, and we're talking about builders potentially reneging on purpose because of costs. Here, they did have someone from the company come in and swear that they did take good faith steps towards getting the proper approvals. So that was something that the court did consider here, but there was someone from the company to say that they did take good faith steps.
So they tried to get the approvals, but didn't get it done in the appropriate time or the appropriate approval.
Yes, but the problem with this case, in terms of coloring how a builder looked to the court, like Aaron said, the approval date was October 20, and they didn't have their approval by that date. You're supposed to notify the purchaser within 5 days of that date to say that we got them or we didn't get them. They didn't do anything. In fact, with a number of purchasers for the next 8 months, they took further deposits. They sent them notices saying, oh, we've been delayed, we're going to be extending. And then when they realized that A, they had this condition, and B, costs had gone up, they said, oh, our deals are dead, which they either were or weren't, depending on these technical objections. And then so they told their purchasers in June of 21. So technically, if the condition was exercised proper, was valid, the deals would be dead. But it certainly made this builder look really bad, right? If he was going to terminate, why didn't he terminate in the middle of November and say, sorry, I didn't get my approvals? No, he took in extra deposits. He told, it just looked bad. And that's, my point to clients is you deal with your clients fairly. And, you won't end up in court.
Well, it sounds like they didn't deal with their clients fairly. If they didn't get their approvals by the time that they said, but they then kept on going and took on extra deposits, one would have, it's almost as if they effectively waived their right to terminate based on not getting the approvals.
You're right, except the way the Tarion has worded that condition, it's not waivable. You're automatically dead if it's there. The purchasers are taking the position that it wasn't drafted properly, they missed some things, so the condition is invalid. So that's the technical argument. But if it's valid, technically you're dead. So the conduct in some respects is irrelevant, but it is relevant. It was relevant for this court to make this interim order when they said,
Aaron, were there other things that made the developer look bad in the court case?
Yeah, so as Lior was saying, they did do a number of acts in the meantime between when they should have given out the notices versus when they did. For example, Mr. Bertho, who was the named litigant, had been provided with builder-approved finishings to choose from in January of 2021 and a condo buyer's guide in February of 2021. So the court really felt that they had been misled during this time to believe that the project was continuing. And then, as Lior alluded to, the deficiencies in the agreements also led the court to see the builder as less innocent in the circumstances.
Fascinating. We're going to take a break for some messages and come back more with Lior Margulies and Aaron Lee of Robbins Appleby talking about condo and low-rise cancellations, contract cancellations, and a really fascinating case that Aaron's told us about that is called this Green Urban case that would appear for the first time. Courts are saying that prices for condos, prices for townhouses can be unique, and that if you take away that opportunity, you might not be able to just supply it with monetary damages. You might actually have to supply it with the actual house, the actual townhouse, and force the developer to complete the project. Absolutely fascinating. We're going to take a break now. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. We're chatting tonight about what might be a little bit of a complicated case, but it's, I think, something that everyone needs to be mindful of because, as Lior Margulies has told us, he's head of the real estate portfolio, the legal firm Robbins Appleby. And how many lawyers have you got in real estate at Robbins Appleby, Lior?
We probably have about seven or eight, plus four paralegals. So it's a pretty big group for a firm of 30 lawyers. Yeah, we make up
and an
a-
incredible articling student, Erin Lee, who's helping you out, correct?
She is. She's now in the real estate rotation, probably for the next few months, and we're very happy to have her.
Fantastic. And the issue is, I think lots of people are looking at condos as investment opportunities or as living opportunities, and pre-construction condos. And I must get an email like every 12 hours. I get an email from some real estate broker trying to get me interested in a pre-construction condo or something like that. I don't know whether everyone does or I'm just on the list, but I get them all the time. It's nonstop. So there's lots of these pre-construction condos that are available. And I guess I didn't realize that they all have this financing condition that Lior has told us about, and also development approval conditions such that they can cancel out. And, when you make a deal with someone, and particularly if you make a deal and put down a deposit, you expect the deal to be honored, and you don't expect people to renege on deals once they made deals. And I'm not suggesting that if someone really truly didn't meet that financing condition or that development condition that they're reneging on a deal because they've got the waiver right. But I guess what Leo is saying is that there are some bad apples that actually might be using these ways out of their deals to get out of the deals and not go forward. And Aaron, I read this interesting comment that I guess it was Bob Aaron, a residential real estate lawyer, wrote about the case that you were talking about, and said that the Burt Halt case presents a roadmap for the many Ontario buyers who have had their agreements terminated. Why did he say that? And do you think that this case, this Green Urban case and this Burt Halt roadmap is going to open up a floodgate of disgruntled purchasers wanting to go to arbitration or courts to seek their contracts to be enforced?
Right. So I think Bob Aaron meant that it shows potential action that purchasers can take if their agreements have been terminated in similar circumstances. So this case is interesting because, as Lior touched on, the court granted a certificate of pending litigation, which required the purchasers to establish two things. Firstly, that there was a triable issue, and second, if the purchasers were successful, that they might be entitled to an order for specific performance of the purchase and sale agreement rather than just damages. So the court held that the alleged deficiencies in the agreements meant that there was a triable issue, and on the second issue, which was fairly shocking in the real estate world, the court held that if successful, the purchasers may very well be entitled to an order for specific performance. And this is exceptional because, as we've discussed, the court held that the land was unique because of the price increases, which is normally thought to be compensatable by damages. So in this case, the court made a determination that because prices had gone up so dramatically, the property was unique, which is generally not measured on cost, but rather the type of building, how replaceable the land is. So future buyers potentially can rely on this case, at least for the foreseeable future, for the fact that their land might also be unique based on rising prices, which seems fairly true in this market.
It does seem fairly true in this market. And, it comes back, and maybe, Leo, you're right, that developers are treating their customers right and are not using this financing condition as a easy way out. But I worry about that, some developers, particularly bad ones, that see these huge condo price increases or real estate price increases on townhomes or whatever, and use a way out so that they can just reprice the deal.
Well, okay, but two things, Brian. Number one, to Aaron's point, it was easy for the judge. I don't want to say it's easy. It was easier for the judge to make this sort of unusual determination that a house that has a new construction that's costing so much to replace is unique, because he didn't have to make the final decision. Two things have to happen. The arbitrator still has to determine that the clause was void. Okay. Number two, that if it was, that the purchaser should get specific performance instead of damages. So that ultimate decision will still be made. All that this judge did is he said there is a tribal issue. He looked at these technical divisions. He said, well, there might be. So he said there might be a grounds. He said, number two, there may well be a basis for getting specific performance. It doesn't say that they'll get it. So for Bob Aaron to say it's a roadmap is an exaggeration. We don't know if it'll ever be granted.
Okay. So it may not be a roadmap, but Lior, do you think the consumers can learn something from this case when buying a home or buying an investment property or investing in pre-construction condos?
Okay, it's not rocket science, but yes, there is something you can learn. Number one, you deal with a reputable builder who has a reputation in the marketplace for producing a good product and dealing with his consumers fairly. Very important. Number two, you look at your risk tolerance. So if you're a new, you look at where the project is in terms of its approvals. Like in this case, they didn't have approvals. As I said, most builders now are not going to market where they don't have their zoning approvals and their site plan approvals for a condo, and similarly for low rise. So if you're looking at a project and this builder is still getting his zoning, or he's still 2 years away, if you have any concern about getting terminated, then you shouldn't buy it. If you're looking to move in, to be honest, if you're a buyer to move in, you have to be very careful to make sure that there either is no condition or that it's going to reasonably be expected to be complied with, i.e. the approvals are there, and if they've got, the project has already sold out and their approvals are nearby, that they should be able to get their financing. You don't have that gap with the construction costs. That's what you should be doing. If you're an investor and you have a long time horizon, in fact, for some investors, the longer the time horizon, the happier they are, because they just put in their deposit and they think prices will keep going up. So they're prepared to wait. So they're not so concerned about when it happens. They are concerned about losing the deal when it gets canceled, because when they go back into the marketplace, they have to pay more potentially.
Well, and the deposits, aren't 100%, but they are typically 15 to 20% of the purchase price.
Yeah, you have this, yes, but so then again, it's risk reward. You get it, like I said, if you go in earlier in a project, there's a higher risk that it may not go, but there's also higher risk for you to make money because you're getting in early. If you want to be assured that it's going to go, you wait until you confirm with the builder that he's got his financing, or he's even got, he's in the ground. The minute he's in the ground, it's not guaranteed. Pretty well, you have a pretty good chance.
Yeah, but if it's in the ground, then he's already got his construction financing. So he's got 75% of the condo sold, and he's going to jack up the prices on the last 25%.
Well, you want to get in early, you take the risk it gets canceled. You don't want to take the risk of cancellation. You may have to pay more.
Okay. So Aaron, Lior has just told us about what consumers may have learned from this case. What about builders? Do you think they're going to learn something from this case? Are they going to treat their customers any differently going forward, particularly when they may have uneconomic projects? And, you just read the newspaper every day. Lumber prices are going up. Concrete prices are going up. Supply chain issues occur. Shoot, you can't get stuff across the Ambassador Bridge. So lots of stuff is happening. What do builders learn and do differently because of this case?
Well, like I said, go ahead. Go ahead, Aaron.
Okay, sorry. I was just going to say, I think it shows builders that they should be cautious of how they conduct themselves and treat the purchasers. Here, if they had been more open about how the process was going and where the conditions laid back in October 2020, they wouldn't have had the same view in front of the court as being less innocent or anything like that, because they wouldn't have had this black hat on of being seen as treating people unfairly.
No, that's key. The one thing, my good builders, and like I said, it's 99% of them are out there, are good builders and conscientious, is that you keep your clients informed. So let's say in this case, there's approval process. They send out approvals or delays. You keep your clients and the purchasers informed as to what's going on. You know what, we're waiting, we're expecting to get it in 3 months. It's going to be delayed. And then when it happens, you deal with them promptly. They didn't have communication here. In fact, any communication they gave them, at least from what I can see, to be fair, was the other way. They said, oh, okay, we still have a deal going. Right. So if you're upfront with people, and we haven't talked about the issue of the unavoidable delay extensions. That's a whole different story. Because of the COVID, closing dates have been pushed out into the hinterland because essentially builders don't know when they're going to close. They don't know when those little semiconductors are coming across the bridge to finish off some part in there. In their but even for them, where they told purchasers we're on hold, we can't tell you when it's going to close. They keep them very well informed. They say, okay, we're up to the 5th floor. You know, we have this problem. They really keep them informed. So purchasers feel like they're part of the process, and at least they know what's happening. They're not kept in the dark, and that's a big thing.
You mentioned two regulatory organizations, HCRA and Tarion. Can you tell us who they are, what they do, and should they be doing something different? Should they be tighter on their oversight or regulation of these pre-construction deals, and particularly cancellations?
Well, HCRA is a new organization that came into play technically about a year ago, February of 21, Housing Corporation Regulatory Authority. And Tarion is the warranty corporation that's been both licensing builders and handling the warranty claims and getting security for projects. The government split the two functions so that HCRA will license a builder. So if you want to build in this province, you have to first go to HCRA and establish that you've got the credentials, the experience. You have to go through courses. You have the security, your financials, and then they give you a license. Then you go to Tarion to say, okay, these are the projects I want to build, low rise, high rise, and then they approve certain projects and they set security requirements, and then they deal with the warranties both for deposit recovery and for deficiencies. So you ask, what are these two guys doing? Well, HCRA was brought in to license and police the builders in terms of conduct. Tarion used to do both, but they had very limited tools in their tool chest to deal with bad builders. HCRA has a lot more tools. Like I said, they can discipline you, they can fine you, they can suspend you, and they're looking at these. They sent out bulletins very recently to builders to talk about how they're using their conditions. Are they doing them fairly? And if they get a builder that's been doing this, they may, I'm guessing, they will haul them in and say, you canceled this project because development approvals, or you canceled this project because of financing. On what basis? What did you do? Who did you see? Tarion, the same thing. If you have a canceled project, and I had one, it was like going through a very rigorous process to establish to Tarion that we legitimately could not finance this project based on the economics. We inherited a project that was, unfortunately, because of the cost, made it uneconomic. And we proved it to them, and they said, fine. And then they let us go forward. So there's a lot more oversight now.
When you're talking about uneconomic, you mentioned that someone was making a 1% return and that they wouldn't go ahead. What's a sort of a typical or average return? What's a target return for a developer to want to actually proceed with the project?
Target return ROI is usually 9 to 12% to make it worthwhile for them, but also it's also from a banking perspective. A lender isn't going to lend to a developer where there's such a thin margin that there's no room for covering cost overruns, and there's no skin in the game for the developer. So when you go to a cost consultant, and that's what we went to one of the best cost consultants in the province, and they went through the economics. They said, we established a Tarion, we said, nobody will finance this. Nobody at commercial rates because of the costs and the low return. 1%, it was 1.2%, I think was the number in that project. You need at least, 8 to 12%. And if it doesn't work, it doesn't work. It wasn't our fault. The other builder, again, sold too early and too cheap.
You told me a little bit about this Green Urban case. I understand there's another case. I think it's called the Castle Point Greybrook case that went to the Supreme Court of Canada, and it was about a large development in the GTA that was canceled. Can you tell me anything about what happened there and what the implications are?
Yeah, and it's sort of interesting because the Supreme Court of Canada just released its decision, I think, within the last 2 or 3 weeks. So there you have a condo cancellation. And again, it was done on the basis because of financing or lack of financing. And remember that there is an obligation, as Aaron pointed out, for both low-rise and high-rise builders in those agreements, that you have to take your reasonable commercial efforts to satisfy those conditions. So if it says you got to get financing, you have to make efforts. You have to do whatever you can. If you have to get government approvals, you have to pursue them. You can't sit on your behind and not do anything. So there was a class action by a number of purchasers who were unhappy because with the cancellation, they get back their deposits, they're supposed to get condo interest, but because interest rates are so low, there is no interest payable. It's a set formula that's a negative actually. So they get their deposits back, they go back in the marketplace, they're going to lose money. So they sued for damages, which is the normal situation. They sued for the damages, their loss of opportunity cost. And in this particular purchase and sale agreement, there was a clause that said if the builder terminates for whatever reason, whether he has a right to do so or whether he doesn't have a right to do so and wrongfully terminates, a purchaser's remedy is limited to getting back the deposit and interest. That's what the clause said. And so the developer said, look, you're going to go to court and how are they going to succeed? The only way they can succeed on the financing clause is to show that they weren't acting in good faith, they didn't use their commercial efforts and so on, which would be, it's possible. No one has tested that. And that's going to be the interesting one if we ever see a real case on the financing condition and how it was actually implemented. But the developer said, look, even if I didn't, even if I breached the condition and I wrongfully terminated, you can't get damages because that's what the clause says. So what's the point in having a lawsuit where you'll win and you'll get $1? So the court looked at that clause, and there were all kinds of arguments that the clause was unfair, it breached public policy. You can imagine that the lawyers tried to attack it from every which way. And at the end, the Supreme Court said the parties are free to enter into an agreement with clauses that are exculpatory, i.e., protect you from liability or limit your liability. And it may have been distasteful, but it didn't go against public policy. And it's not for the court to say that, well, you don't like this clause, so we're going to throw it out. So in that case, the Supreme Court said that the developer couldn't be sued for damages, and therefore there was no point in proceeding with the class action, even assuming that he wrongfully terminated. So that clause is, obviously affords, significant protection for developers who have those clauses in their.
Well, I guess what this reminds us of is read those contracts. And if you had read that contract and saw that clause, you should either strike it out or not invest in that condo, because what it's saying is that the developer isn't standing behind its word effectively, isn't standing behind his word or her word. Anyway, we're going to take a break for some messages and come back with some concluding comments in just a minute. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 96. It's a real pleasure for me to have back Lior Margulies, who is the head of the real estate group at Robbins Appleby, a law firm in Toronto, and an articling student, Aaron Lee, who has done a really good job reviewing some of the legal cases that we've been talking about today. Lior, is this actually good news or bad news that these cases have come to light?
I mean, I think it's good news because it heightens everybody's awareness of the issues. It's good, it's good for builders to know that the courts are going to look very negatively on cancellations unless you act in good faith and follow the agreement and follow what's morally correct. So that's good. I think most builders fall in that category. And for those that don't, there's a warning that the courts are going to, I would say, bend over backwards for purchasers if you do them wrong, or you're perceived not to act really with the white hat. That's the builder.
So it's like that old thing about the best sunlight is the best disinfectant, and by exposing some of these cases, even if they're bad, it's good because everyone will be more mindful of everything.
Absolutely.
Aaron, you're probably in that age group where you're starting to think about buying a condo. What has this whole process taught you about what people like you and other people that are buying condos should be mindful of?
Right. So myself and other consumers, I think from this case and the cases we've been discussing, should just really be aware of the risks involved. So there are risks involved in signing pre-construction agreements and the potential termination of those. However, pre-construction can be a great investment source. So I think just being aware of the risks involved and assessing your own risk tolerance is something important for potential consumers.
Aaron Lee, articling student at Robbins Appleby, and Lior Margulies, who is head of the real estate group at Robbins Appleby. Thanks so much for joining us and telling us a little bit about this case. And, I think there's another big issue that has come out recently in regards to this new housing report that's come out. And if you guys want to give that any thought, I'd love to do another show talking about that, because I think that's going to be another game changer. And it's interesting. We've got huge amounts of condo developments in the Greater Toronto Area, townhouse developments, single family homes, etc. But all the reports say we're going to need a lot more if we're going to house the people that are coming to Toronto. The predictions are that there's 1.5 million people coming to the Greater Toronto Area in the next 10 years. And that's a lot of housing that we got to build. So you guys are going to be busy. You're going to need another lawyer. Lior, you're going to have to hire Aaron.
Well, that may well be.
Thanks for joining us, everyone. Have a great night. Aaron, Lior, thanks so much for your words of wisdom about what both builders need to be mindful of and what consumers need to be mindful of. That's our show for tonight. Thanks, everybody. Good night.
Thank you.